As it has been rightly said, an ounce of mediation is a worth pound of arbitration and a ton of litigation. Alternative dispute resolution is not just a mechanism, it's a mindset. One that seeks justice through dialogue, resolution over retribution, and progress over prolonged conflict. Ladies and gentlemen, distinguished guests, faculty members, and esteemed participants, I, Akhil Jetli, on the behalf of entire MERI fraternity, extend a warm welcome on the seminar of Alternative Dispute Resolution, a Progressive Approach to Justice. We gather here today not merely as attendees, but also as active contributors to the transformative dialogue that delves into the heart of legal future. This seminar is more than a platform. It is a crucible areas for ideas, a space where expert presentations and panel discussion will weave together. In order to be free, Professor Lalit Agarwal Sir, Vice President, MERI Group of Institutions, a distinguished educationist and institution builder. Sir has dedicated over 3 decades to the establishment and development of prestigious educational institutions. Under his leadership, MERI has flourished as a center of excellence in education, providing quality learning in diverse fields such as engineering, management, law, journalism, information technology, teacher education, and international relations. I now request Sir to please give us the welcome address.
Thank you, Akhil. Let me first welcome Mr. Joe Tirado and Pawan from Mediate Group for this seminar on alternate dispute redressal systems, a progressive approach to justice. Justice in India is time consuming. And at the same time, if we see the international scenario, it's expensive. So the need of alternate dispute redressal systems are very well needed, as well as are important to see that we all move forward in life. We all know mediation and arbitration are one ways of going for the ADRs. But let us try to use these systems rather than going to the court of laws for dispute redressal. I was just talking to Joe, before coming in here. We all know that in India, the number of cases in the court is quite high. And each and every day, it keeps on increasing. And hence, to give value to your own client, it's very important for all of you to see that the justice is given to them well in time, as well as in a way that satisfies all. And hence, mediation and arbitration are very important. You as students of law must learn skills and systems to be a part of the mediation or to be a part of arbitration. Of course, going to the court is also very important. But I think if you start thinking about your career in these areas, it will be of a lot of use to you. And I think although it is also a very competitive space, but still you will have a lot of opportunities in this place. Joe would be talking today about the international scenario, and I think Pawan will tell us about the career opportunities in these areas. So let's have a good and nice learning. Thank you. And welcome once again, Mr. Tirado and Pawan. Thank you.
Thank you, sir, for sharing such motivational insights. It is my honor to introduce Mr. Joe Tirado, sir. With a distinguished career spanning several decades, sir has built a reputation as a leader expert in alternative dispute resolution. He has acted as a counsel, arbitrator, and mediator in numerous high-stakes commercial and investment disputes across diverse industries. Mr. Tirado is widely recognized for his deep understanding of intricate legal and regulatory frameworks, his ability to navigate multifaceted negotiations, and his unwavering commitment to fairness and justice. A sought-after speaker, profile author, and thought leader, Sir has shared his vast knowledge at international conferences, legal forums, and academic institutions, mentoring the next generation of dispute resolution professionals. His dedication to excellence, integrity, and innovation has earned him global recognition, numerous accolades, and respect for his peers. It is a privilege and honor to extend a heartfelt gratitude to our distinguished guest. As the part of our tradition, we felicitate our guests with a token of respect and gratitude. Today, we are privileged to have Mr. Joe Tirado with us, and we eagerly look forward in gaining insights from his wealth of experience. Please join me in welcoming, sir. Please.
Right. Good afternoon. Namaste, everyone. It's a great pleasure to be here. Thank you for that very lovely introduction and nice gifts. Thank you so much for that. It's a great pleasure to be here. I want to stress first and foremost, this is a seminar, not a lecture. So please, 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 if you have a burning question, ask it now. I mean, yes, we can talk afterwards, but I think we all benefit if you share. No question is stupid. I think it's never ceases to amaze me. Things I think, well, I know that, don't I? And then somebody asks it in a certain way, sees it from a different perspective. It makes me see things from a different way. And I think it's interesting to have a debate. It makes it less boring as well when it's all just one-way traffic. So please feel free to interrupt, raise your hands. Don't heckle or throw things at me, but I mean, at least, wave for attention. Often it's best to just ask the question as we're going along. If I'm going to deal with it later on, then I don't mean to be rude, but just bear with me, and I'll just say, look, I'm going to come across that. But I think I can speak for both me and Param that we very much look forward to those questions and your intervention. Now, this is an extremely broad topic of ADR, and what do we mean by ADR, often known as alternative dispute resolution. I'm going to put a marker right down immediately. I'm not a big fan of the term ADR. I'm a big fan of ADR. Obviously, that's not what I do most. I think it's probably better to say appropriate dispute resolution mechanism. But be that as it may, what do we mean when we say alternative? Well, it's generally alternative to litigation, because that's effectively the default dispute mechanism for the administration of justice all over the world. And the reality is it's failing us all over the world. And it would be lovely to think that this is all because people have seen the light and accept that mediation in particular, or the other forms of dispute resolution, have particular advantages that commend them for consideration. But the truth of the matter is they're forced to do it because you may not have a very good court structure, but even where you do, they're so overwhelmed, they just can't dispense justice within a reasonably, first of all, a time period, and secondly, there's a cost aspect to it. And they are essentially a result of courts realizing that, governments realizing that they can't, because often it's the state who's funding it. Those of us who are taxpayers are doing it now. All of you will at some point be paying taxpayers. Your parents certainly are paying towards it, and it's not able to keep up with the demand. So this is where the need for an alternative process comes from. There really are, there are many, many different types of process. And one of the things I want to say, I think most people here are lawyers, but could I just ask those who are not lawyers, I'm not going to pick on you or anything to embarrass you. Is anybody who's not a non-lawyer student here? Somebody studying economics or management? Or is it, okay. Because I really want, I mean, I'm delighted, and it's important that the future lawyers who are going to act as counsel are part of this conversation and take it forward. But I think also there's a much wider community. It does frustrate me all too often that lawyers end up talking to lawyers and often preaching to the converted. And there's a whole constituency out there of people, your colleagues, who will be management students who will be your future clients, and they need to be aware of these processes too, because the bottom line is it hits company bottom line disputes. Disputes are unpleasant, nobody wants them, but they're a fact of life, and the reality of it is you can hope for the best, but you need to be prepared for the worst. And having at least a basic understanding of your options is, I think, an absolute necessity. I think you're doing your company a disservice if you don't engage, because it's the previous practice of basically passing it all on to the external lawyers and then blaming it all, moaning about them and blaming them if it all takes too long and costs too much is not really excusable these days. And people, there needs to be far greater accountability. And in order to challenge your lawyers, you need to be better prepared and equipped yourself as to know what's out there. So I think it's important that the audience is far wider, and we will look for reasons that hopefully will become apparent. We're going to, given the time constraint, there's an awful lot to go through, so forgive the need to kind of canter through it. What we've agreed is probably, I'll spend the first 30 minutes just looking at international arbitration, because that, I think, is the premier, the most accepted and dominant form of international dispute resolution mechanism that out there, for reasons I think are self-evident, but we need to talk about. And I just wanted to highlight that, because that's the big daddy in the room, if you like, or the big mama, so we're not being overly sexist. But mediation it's been fascinating coming here on this trip. I mean, I've been fortunate enough to come to India for many years now, over 25 years, and each time I come, there's been developments and movements and up and down with whether you want arbitration, don't want arbitration. But the thing that's where the needle has really moved is in the area of mediation. A lot of chatter, a lot of enthusiasm, a lot of desire for that to work. It's still early days. I think time will tell whether or not that chatter becomes, permanent, and it's a permanent fixture. But having candid, frequent conversations about what needs to be done and where we are, I think, are all part of the process to ensuring that it does become an accepted form. And I'll touch with it very briefly, but I think Param will just talk us through the principles of mediation, which is often, you will often see the term conciliation interchangeable. Conciliation does exist in another world as a separate entity, but to all intents and purposes, we know, if I'm not going to refer to conciliation other than just having put that marker down, but when you hear it, it more normally means just mediation. So he's going to talk us through that. And importantly, and I hope from your point of view, it will be really helpful, is to give you some outline, some tips about getting a job in this area, if it interests you. It's not for everybody, but hopefully it's going to be of interest, and I think has huge advantage, not only here domestically in India, which I think is an exciting time to be an Indian lawyer, arbitration lawyer in India, but globally too. So there's the world in many ways is your oyster. So the main reason, so I'm going to, without further ado, I think kick off with international arbitration. And the basic, I always say it's basically privatized litigation. And the whole idea of that really is to create a neutral forum and a level playing field for everybody, so everybody knows the rules of the game. So everybody has the same advantage, or you could look at it the other way, the same disadvantage. I mean, the reality of it is litigating in your home jurisdiction, whatever you think about it, however you might complain about, there is a comfort factor that you know the way these works, the community that lives in that ecosystem. And even if it's not true, there's a perception from outside that may give you an advantage. And so coming in as an outsider into a jurisdiction you're not familiar with, even if they speak the same language, seem to come from the same kind of historical background, it makes people feel uncomfortable. So the whole idea is having a neutrality. But this is where I say it's not, the alternative is not that much of an alternative, because the arbitration, unlike mediation, as you will be hearing, is all about providing a decision known as an award. So it's an adjudication process. And the reality of it is, when it was initially launched, it was all kind of painted as a cheap, quick alternative to litigation, which in the early days probably did deliver. It then got kind of abused, became more and more complicated, and really you're in many ways the complaint now, it just mirrors litigation. So all of the complaints that you might have had about litigation, really you see happening in the international arbitration space. It's not so bad, and actually some courts have, as a result of people voting with their feet and moving elsewhere have changed their practices and their procedural rules, and may actually be quite attractive venues in their own right. So there's still a place for courts, obviously. But arbitration, as I say, has effectively become the privatized form of litigation. And actually saying the word privatized is not, the next thing is that it's private. A lot of the litigation is, of course, by its very nature, public. It's a public service, after all, in many jurisdictions. And the beauty of arbitration, and this is certainly in commercial relationships, is, at least in theory, I mean, I think in practice it's amazing how much stuff actually leaks, so never think it's totally watertight, but it is to provide a private forum for parties to resolve their disputes without the embarrassment and awkwardness of adverse publicity. And associated with that is the concept of confidentiality. The two are slightly different. And you can't assume, I think that's the first thing I would say about arbitration, don't assume you get automatic confidentiality. There are some rules that don't cover it at all. But most jurisdictions will have a confidentiality kind of provision in the Act to say at least some part of it is. And most rules will have some kind of guidance, but it's pretty... it varies a lot between jurisdiction to jurisdiction. So don't assume that. But I mean, essentially, what you will find, the main reason, as I've said, for going for arbitration, a lot will depend. Whether you decide to go litigation, arbitration, depends on the identity of the parties, where they're from. Key thing is where the location of the assets are. And that's always a weird thing, but certainly in arbitration, but in any litigation, you need to look at the end of the process right up front. And often people forget to do that. You focus so much on the process that you've participated in a beautiful arbitration, but all you're going to get at the end of the day is a piece of paper. And you need to go and enforce that somewhere. And if you haven't thought that through, that's a whole new process. It's another process, and you start effectively all over again. And wherever you're going to enforce may well put some considerable hurdles in your way. So it's important to think about where the assets are, and it may be that having a court behind you might be helpful than having an arbitration, which effectively lacks the teeth that a court does, because ultimately courts already have the capacity to be able to fine you. Closest thing we get to that in arbitration is sanctions and costs, maybe. But obviously the big stick is potentially contempt of court and be sent to prison. And it happens. It happens. Not often, but it happens. So in terms of neutral forums, what we're seeing on last data available periodically, we see these surveys circulating. I'm glad to say I've been a beneficiary of that. London tops the poll, has done for the last 20 years or so, but it's under serious threat. Singapore has been chasing us for quite a while. We booted out the French about 20 years ago. That tended to be the kind of go-to place. And Switzerland, it always surprised me when I first started out. There was a lot of Swiss cases. I hardly ever see them anymore. It's still an important venue, but London, equally with Singapore now, there's going to be a new survey at the end of this year, beginning of next. That's going to be an interesting one to watch to see whether Singapore goes ahead. But other key jurisdictions where you'll see arbitrations and neutral forum is Hong Kong, Paris still, but less so New York, among many others. So as I say, one of the advantages is it can be shorter, and by that I mean it's you have the ability to craft the procedure. We're working with the arbitrator. In fact, it's the arbitrator working with the parties who will try and agree a procedure that is obviously where there's due process, but to ensure there's no undue slack in that process to get it moving. And indeed, there's an obligation as us, certainly in the UK, to proceed as cost efficiently and as time efficiently as possible. There's an actual requirement in the Act for us to do that. So we're creatures of contract. There's a contractual implied term at the very least, but the Act there is behind us to get on with it. So even if parties are quite happy to be relaxed, of course, party autonomy should trump, but it's our job to at least question whether that's reasonable, acceptable, or see if there's ways that can be done in a slightly more efficient way. And certainly as a result of that, you can craft procedures that are much cheaper than courts. Expertise, the ability to choose your tribunal, I think is a fantastic benefit that people, again, all too often overlook. It's a way of stacking the odds in your favor. You want somebody who understands the kind of dispute you're talking about. Litigation, you may well get complete random allocation of judge who's never maybe a criminal judge. All their career are dealing with a high, complex energy type case. You can select your arbitrator, and that is best to do by consent. Ideally, I would stay away. The institutions will do it in all, in the absence of an agreement, and indeed the courts will help out if they are required to. But that's a really important, I think, added benefit. It's a one-stop shop. Generally, you get a final binding decision. It's very rare to have an appeal. The limited grounds for appeal really are all about due process, not unreasonable. If you detect there's been a corruption and can show that, you may be able to challenge an award, but effectively not. So you avoid the potential multiple rounds of appeals, which will cost more and add delay. So that's definitely an appeal, but that's obviously only advantageous, particularly if you win. If you lose, you might have a different view on that. But it's a bit of a as I say, a one-stop shop. You have to bear that in mind. I mentioned about confidentiality, being cautious about that, and I think really the biggest single, advantage of international arbitration over most litigation is the enforcement issue. And it's really sad because I very rarely use PowerPoint these days, and I'm hardly looking at my own slides now, but the two slides I wanted to show you, because it really is an example of a picture. Hey, how did you do that? Okay, well, I'm impressed. Well, now I've built it up. I've got to see. Okay, so have you got both of them?
Yes.
Right. So what you have here is a slightly outdated map. That's the first thing, because one thing you'll see. He was, yes. We're in blue over here. So this is all the European Union and the wider European Free Trade Zone. Of course, we're no longer in it, so we don't have the benefit of any of this blue. The reason I picked on this is because this is the position from the United Kingdom, where you have reciprocal agreements, including some pretty big important countries, for the recognition and enforcement of court judgments. And it's global, as you'd expect. A lot of it is related to the old Commonwealth, and you won't be surprised to see Australia, Canada. Interestingly, USA is not there. But I put that up there because it's before, as I say, sadly, is slightly shrunk here. But even without the blue, it's one of the most extensive regimes you have for the enforcement of court judgments. So it's a little bit old, so bear with me. But then if you compare that with the next slide, okay, green. Green is good. Basically, green means these are all the countries that have signed the New York Convention for the recognition and enforcement of foreign arbitral awards. So the theory is you can go with your Indian award to any of these green countries and get it recognized and enforced as if it was a local judgment. That's the theory. In practice, we all know sometimes it doesn't quite work like that. The good news is again, this is an old map. There's a lot more of this. It's actually green now. It's something like 90% of all UN, it's the most successful treaty they've got, have signed up to this. And if you could just flip back to the other one, just to emphasize the point. So look how much is not covered with the white. And if we go back to the green again, then with that, I won't labour the point anymore. It's extremely useful. And so the point is where obviously normally you would think about going, thank you. You would go where the assets are. Normally, the assets are located where the party's located, but it may be that they have assets elsewhere around the world. Classic one will be bank accounts. A lot of it goes through London, New York. You could seize those, and if, as you see, those jurisdictions part of the New York Convention, they will help out. They should do if they're an arbitration-friendly jurisdiction. So that's arguably, I think, one of the biggest sells, depending where it is. I mean, so if it, between European parties, it's generally perhaps not such a big sell for obvious reasons, because we have our own kind of internal recognition, or had when we were part of the European Union.